I've been a lawyer for over 32 years, and people often ask me, what are the damages in a personal injury case in Texas? Hi, I'm Mark. I'm a Texas attorney, and in today's video, we're going to learn about the details of what is a personal injury. What are the damages in a personal injury case in Texas? Well, first and foremost, your damage claim must be supported by sufficient evidence. Understand that any case that goes to trial will be subject to appellate scrutiny, and your evidence will be meticulously reviewed to see whether or not it meets the law requirements in order for you to keep the award that you recovered at trial. Damages include lost earning capacity, physical pain, mental anguish, physical impairment, and disfigurement. Is physical pain and mental anguish the same thing? The answer is no. When you go to trial, you will have what's called a jury charge, which asks a jury specific questions about your claim for damages. On the jury charge, you will find the ability to make a claim for physical pain in the past and physical pain that you may suffer in the future. This element of damage is different than the mental anguish that you suffer as a result of your physical injury. You can also make a claim for mental anguish in the past and in the future, assuming you have evidence to support future mental anguish. The idea of physical impairment is something that goes beyond physical pain. It goes beyond mental anguish. It's also not something that affects your ability to earn a living. The idea of physical impairment is often described as a loss of enjoyment of life. The evidence required is to show that the activities you engaged in outside of work for your own enjoyment purposes are those types of things that have been affected to the point that you can no longer enjoy those activities. If you have hobbies that have physical requirements and you can no longer perform those tasks, that's an example of physical impairment. What are some examples of physical impairment in a personal injury case in Texas? Physical impairment is often described as a loss of your former lifestyle, the things that you do outside of work. If your injuries have affected your ability to perform those activities, that is the type of evidence that you would submit to a jury to assert a claim for either physical impairment in the past or physical impairment in the future. The best way to explain physical impairment is to look at a case example and see what evidence the Court of Appeals found sufficient to support a claim for physical impairment. In the case of Punitive versus Britain, the court considered the following evidence. First, difficulty eating and communicating with others. Second, continuing inability to sleep due to sharp pains, plus inability to run, bicycle, participate in triathlons, and play with children. Third, past inability to walk and future difficulties in running, standing, and climbing. 4, inability to ascend or descend stairs or kneel and difficulty in standing for long periods of time. 5, loss of 75% of strength in the left arm, which subsequently contributed to plaintiff's falling, breaking her leg, and being confined to a wheelchair. And 6, difficulties performing yard work, car maintenance, and playing racquetball. If you believe you have physical impairment into the future, it's important to consult with an attorney near you and confirm if your evidence is going to be sufficient to sustain an appellate review of your case after a trial on the merits. Can you recover for disfigurement in a personal injury case in Texas? The answer is yes, and it's often referred to as cosmetic harm. The value that a jury may place on a disfigurement claim depends on the nature and severity of the damage to your body, where the scars are located, and how it will affect you into the future. Understand that disfigurement is a separate category of damages and is not the same thing as physical impairment, because physical impairment looks at your inability to do tasks that you could have done before the accident, but for the injury, now you can no longer do. Can you recover future lost earnings in a personal injury case in Texas? The idea of lost wages in the past is a relatively simple concept, right? You look at how much you were earning at the time of your injury, and you can easily calculate the amount of wages that you missed from your employer. But the idea of lost earning capacity does not stop there. Under Texas law, lost earning capacity means all the things that you can do to earn income based on your education, your training, and your experience, and not just the job you were in at the time you were injured. The jury is allowed to look at all of your abilities and look at your lost earning capacity and not strictly your lost wages in the past. If you have suffered an injury that is preventing you from earning wages in the same manner that you were before the accident, for example, if you use your body to make a living and your body has been harmed to the point where you can't earn the same wages you were earning before, then the jury will be able to look at your lost earning capacity, your ability to do all the things you do to make a living, and determine a value for lost earning capacity into the future. Can you recover punitive or exemplary damages in a personal injury case in Texas? The phrase punitive comes from the idea of punishment. The phrase exemplary comes from the idea of making an example of the conduct for others. Both phrases refer to the idea under Texas law that someone has engaged in gross negligence, an entire want of care, the type of conduct that we want to discourage people from engaging in the future. As a result, Texas law will authorize punitive or exemplary damages so that in the future, others, whether they're individuals or corporations, will engage in such conduct. Understand that under Texas law, there are certain limits to the amount of punitive or exemplary damages that you can recover. Can you recover attorney's fees in a personal injury case in Texas? Under Texas common law, a negligence claim does not recover attorney's fees. You get your elements of damages, such as physical pain, mental anguish, lost earning capacity, physical impairment, disfigurement. Now, there are a couple of examples where people may be injured and the claim arises out of that injury where an attorney fee might be paid. One example is when you're represented by a lawyer before the Texas Department of Insurance Division of Workers' Compensation. The Texas Labor Code allows the attorney to be paid for representing you on your insurance benefit claim against the workers' comp insurance policy. Even though you've been injured and the case has to do with your injury, it's actually a claim for medical and indemnity benefits under an insurance policy. In that circumstance, the lawyer may be paid not to exceed 25% of any particular indemnity check that you receive based on the hours the lawyer works approved by the Division of Workers' Comp. Another example of a situation where attorney's fees might be recoverable as a result of an injury is is when you have a first-party claim against your insurance company for uninsured or underinsured motorist benefits. Even though you have an injury claim, you're actually pursuing a claim against an insurance contract. In those circumstances, there may be mechanisms in which you can recover attorney's fees. That's all the time we have. The outro music is coming. See you in the next video.